get-togethers like this that are more regional. So we're kind of feeling our way around and trying to get a little more supervision, a little more structure. But I really appreciate the turnout that we've had here today so far. So I want to thank everybody for coming. I want to turn the program over to, I just talked to Roger on the phone for the first time 2 days ago and was very impressed with what we were talking about, what was going on. So I told him it's a pretty unruly group, and you guys had a lot of questions. So be a little bit easier on them in the beginning. But Roger, honey, we're happy to have you here today.
Thanks. All right, well, thanks. Yeah, well, he's oversold me maybe there. I don't know. You'll have to be the judge of that. I'm used to only having 12 people at a time that I talk to, so this is a little different. Just 12 jurors. But my name's Roger Honey. I'm with Carlson Law Group. And Carlson Law Group is a law firm of about 10 lawyers, 7 in Southern California and 3 up here in Northern California. And we do real estate brokers, errors and omissions litigation throughout the state. I've had cases up in Redding, Crescent City, all the way down to Fresno, Hanford, what is that, Kings County? I think so. And of course out here, Sacramento, Placer County. We service the entire state, and we work through several insurance companies, one of which is Crest Insurance, which insures you folks for your errors and omissions. Is that not a question already? In terms of questions, I know some people like to have questions at the end. Some people, don't mind questions coming as we go. I'm willing to do whatever you folks think is best. Probably the question should be on the topic that we're discussing at the moment as we're going through. As I said, I'm mostly a trial lawyer. I've had a very busy trial practice, especially in the last about 5 years since I moved my practice up here to Northern California. I opened up the Northern California office in 2008 of Carlson Law Group. 90% of our client base, maybe 95, is salespeople, brokers, dealing with transactions, at least allegedly, that have gone bad. Of course, a lot of garden variety disclosure type things. With the changing market, we're seeing a lot of those loans back in 2005, 6, and 7 rearing their ugly head right now. So we get a lot of that. There is clearly a lot of issues these days with REO sales and short sales, and those are things we'll touch on today. As you can see, I don't know if I came up with a real clever title for everything, but I think it's pretty descriptive and accurate. Avoiding litigation and other hazards. I've told a number of my clients that litigation is not necessarily what you do. Sometimes it's just who you do it with, especially here in California. California is a very litigious place, and you do enough transactions, unfortunately, it's just a sign of the time. So you can minimize it, you probably can't eliminate it altogether, and avoiding litigation and other hazards that you may encounter. And those other hazards, of course, include discipline, disciplinary complaints and accusations from either the local association, ethics committees. I'm sure your local association has an ethics committee that investigates issues every once in a while, and of course DRE complaints. Hazards that you may encounter that are possibilities out there include criminal accusations as well. There's some stuff, obviously, we have seen in the late 2000, like I said, 2005 through 2007 and 8, a lot of things that are clear loan fraud. And there are some lender fraud and lender issues today still going on. So the way to avoid litigation and avoid these other hazards really is to get back to, in some respect, just the fundamentals of your real estate practice. How you deal with your transactions from start to finish, and not necessarily in your transactions, your listings as well, right when you get the listing all the way through closing. Important issues you've probably been told since the day you first walked into your first real estate office. Documenting your file is one of the most important things to do. We'll touch on that. Your fiduciary duties, which is something that is run into a lot. I think there have been some issues lately that we'll touch on today that really deal with your fiduciary duty, which is the duty of utmost care that you owe to your own client, as opposed to, of course, the other side of the transaction. Your duty of good faith and honest and fair dealing. These are all terms just directly out of the Civil Code. Then we'll touch on a little more difficult situations that people find themselves in. Fraud, lender fraud, deceitful acts, and then criminal statutes and criminal accusations that can come along. Like I said a moment ago, this is a thing you were taught the first time you ever walked into a real estate office. Document everything. It is so important when you get in a bad situation and someone has made an accusation against you to have a very well documented file. Rule number 1, if it's not in writing, it didn't happen. Rule number 2, let's go back and see rule number 1. There is such a presumption when you get in front of 12 jurors that, first of all, I think real estate agents, in a general sense, don't have the best reputation. I don't think it's a bad reputation. I think there is a feeling out there that you're just in it for the commission. There hasn't been a case that I've been involved in that the plaintiff's attorney doesn't try to hammer on how much your commission is. You guys make so much money on these transactions. One transaction and you're cashing a check for thousands and thousands of dollars. That's what they try to impress upon the jury. And I've had jurors that I've questioned in choosing jurors for a jury that just say, I just think real estate agents get paid way too much. And they don't understand that you've got a hefty, whatever your arrangement may be, maybe a desk fee and, a transaction fee, and you got to pay your transaction coordinator, and all of a sudden, you're not cashing a $50,000 check, even though that may be, or $10,000, whatever the commission may be. Yeah?
How are electronic signatures used?
I don't know if anybody's dealt with electronic signatures too much. The litigation I've seen, there has not been a problem with it. And we'll get into documenting the files here in a second. And there's excellent ways to document your files these days, and easy ways. You probably really need to be an email person to be in this business, because email is just an excellent way of documenting your files, and I'll get into that in just a second. Really, when we're talking about documenting your file, you just really have to have some kind of written follow-up to any significant or potentially significant activity in your case. And I don't think I'm telling anybody anything new. As I said, email is an excellent way to document and make it virtually indisputable, and I haven't had any disputes that I know of. The date the communication went out, exactly who it went to, and exactly what it said. It's an excellent way to document things. As I mentioned earlier, this kind of bias against real estate agents, I see it every once in a while when I'm choosing a jury. I think there's a presumption by the juries, and I know I use it in my cases that I bring to trial in a positive way, is you're taught, it's your custom and practice, it should be your custom and practice to write down every significant event, whether that's in your file jackets, whether it's in letters, emails, faxes, what have you, that there will be a presumption that if it's not in writing, it didn't happen. Legally speaking, a disclosure that the roof leaks verbally by you to your client, if you're the buyer's agent, or to the other side, is legal. You fulfilled your duty. but you're never going to get that plaintiff, that buyer, to admit that in court. That never happened. You know, that's the get everything in writing situation. So again, it comes down to if it's not in writing, once you get in front of that jury, in front of that judge, it just didn't happen. These items are perfectly acceptable items to document your file. You probably have escrow checklist or document checklist to make sure you have everything in your file. Conversation logs are excellent. Letters. From time to time I'll get questions saying, well, yeah, but you know, that you really can't verify that the letter was received. That's true. And you can't really verify, and I've had clients do this, and it backfires almost every time. Backdate your diaries, falsify them, because it's possible to do that with these things. Again, when you get to things like emails, those, I'm sure you can doctor those up and try to cut and paste an email, but it's a lot harder. Facsimiles, you got a facsimile transmittal to show that your fax went to your client or to whomever it needs to go out to, so you got a good record in those things. If you have a conversation with somebody, whether it's over the phone or what have you, and you write your log notes, if all you got is a cocktail napkin, write it down. I know, and I can't recall if it was John or David mentioning filling out your RPAs, your residential property agreements, fully. Don't, and some of this stuff is pretty basic stuff, but fill out your forms completely. Don't ever have your client sign something, sign an addendum, and you fill it in later. I've had those accusations in court from a plaintiff to say, he gave me the addendum, it was blank, he told me to sign it, and then he filled it in later. And the nice thing was, and I assume you all use WinForms, it's virtually impossible to do that with WinForms because you can't generate that document without that, the addendum up there already filled in. You can't generate a blank and then fill it in later. So that's the nice thing about WinForms. So those accusations usually fail. Backdating signatures, I think I have that in here. Don't backdate or forward date anything. I just had a deposition the other day that really didn't go too well because my client clearly had her house listed. She was agent-owned property, so she was selling her own property. She had it listed for a long time, probably too high, but what have you, she wasn't too anxious in selling it. She had her TDS filled out in 2007. She filled it out. The house was listed. She did her TDS. She had it filled out. We'll talk about this TDS a little bit later, too, because it was a doozy. She had it 2007. Property was on the market until 2009. The issue in the case was, among other things, whether or not there had been any work done on the property without permits. All she did when she finally sold the property was change that 7 into a 9. And it was real obvious. And her excuse was, it was accurate when I filled it out back in 2007. But of course she had some renovations done without permits in the meantime. And she just changed the date and handed out the TDS. This was one of the worst TDS I have ever seen, and the testimony she gave was absolutely just horrific. When we went through, I think it's page 2, is it item C that goes through, have you ever had, work done without permits, work done not according to building code, you had any landslide, slippage, you check the boxes, no. She was asked, why did you check the box, no? Well, because that's what you're supposed to do. You're just supposed to check the no boxes. And once that comes out, you got your stenographer there. There's no turning back. She also said that the only transaction she's ever been involved in as an agent is buying and selling her own property. I think she probably had some pretty poor supervision as well. She really did not know how to do the first thing in a transaction. You get to the agent visual inspection on the last page of the TDS, and it, of course, is blank, except she knew she's supposed to sign it there. And that isn't, you know, that's not bad. You always like to, you've probably been taught to, you know, put something in there. And by the way, it's better to disclose early than it is late in the escrow, because your buyers are still extremely in love with the house as long as you do it early. She left it all blank, so she didn't even check the box that says, I have no items to disclose. All she had to do was check that. Now there's a big presumption that she never did her visual inspection. Now she owned the house, she lives in the house, she probably, you know, quote, inspected it all the time. Raises other issues when you're an agent, you're selling your own property. You have your, not only your visual inspection, but of course your general disclosure as a seller too. She doesn't do a good job on that. So that is a case I'll be going to mediation on Monday, and it's just a matter of what the damages are at this point. Not a fun case. Your contracts need to be legible. Have your seller sign the rejection of an offer. Now that isn't something that's mandatory, of course, but it's just a good idea, because if that offer or counter offer comes in from the buyer and you just reject it, calling, hey, no, not good enough, we're going to wait for other offers, and then no offers come in that high, guess what happens a year from now when when the seller finally sells it for, you know, $50,000 less? I never got that offer. They never even showed me that offer. You know, if she signs off, you know, you could just reject it. I've seen that rejected right across the counter, or right across the offer, and your client signs it. That just gives you the peace of mind to know that you got some documentation to show that happened. Yes. Yeah.
So how do you force that issue? I mean, it's real prevalent in this market. You know, multiple offers come in, you get beat out. They just call you up, well, they selected another offer. You say, well, how do I know my offer's been presented?
Oh, so you're talking from the buyer's perspective.
Correct.
That is very difficult. There is no tried and true way to know that your offer got in front of the seller's eyes. And that's an issue that comes up in short sale situations a lot. And that is a place where you, as a buyer's agent, can do a little checking, because you probably know who the bank is, and you probably can find out who the asset manager is, and find out if he was, you know, if he's been notified of any offers coming in. Maybe not, but that is something that happens, because there is no big incentive for the seller to take any particular offer, especially on a short sale. Touched on this, your fiduciary duties, your duty of utmost skill and care that you owe to your own clients, whether that be the sellers as a listing agent, or the buyers as a selling agent, a buyer's agent. One thing that has come up recently, and it's not a new tactic, is this idea that I've seen problems running into this, a low listing to create multiple offers. And I don't know, it's nothing that's wrong. You can't. It's something that you are certainly permitted to do. You got to explain to your sellers the concern. There is a concern that if a full price offer comes in, by the way, you don't have to accept it. Your seller does not have to accept the full price offer. But what that may do is trigger their obligation to pay you guys whether that property sells or not. Because in your listing agreements, assuming you're using the CAR form, if you bring to your seller a full price offer, they're obligated contractually to pay your commission, whether or not it closes. So you need to make sure you explain those issues to your client. There's obviously, and especially in short sales, but really anywhere, steering your sellers into a dual agency situation, not presenting all the offers. There is a lot of interesting things going on these days as far as steering your sellers into a dual agency situation, not presenting all the offers. I know there are situations out here, and it isn't really and it isn't really statewide yet, and we see these little schemes and scams in pockets. It seems to be prevalent out here, and that issue is you get, especially an REO listing. And REO listings, of course, the bank is really getting particular about those listings, and they kind of govern them, and they'll give you the situation that if you're a dual agent, we're still going to only give you 3%. And what happens is that some agents will get in a dual situation and want to get the full 6% because the listing may say, you'll get 6%, but you'll only get 3% if you're dual. So what they do is they don't want to be dual. They want to bring in their buddy from another agency. Any transaction, of course, between you and you would still be a dual agency because it's all within the Connect umbrella. So you go out and you get your buddy from another agency to just be the buyer's agent. Don't worry, you don't have to do anything. And I'll slip you $1,000 in a commission. Well, what you've done there is you have absolutely and definitely breached your fiduciary duty, because one of your main fiduciary duties is to always put your client's interest before your own. And what you've just done is you have manufactured a way to cost your client, and yet we all know it's just a bank and it's not their life savings or what have you, just one little transaction, almost, no harm, no foul. But they're still your client, and you still owe them a fiduciary duty, and if you're doing that, this is something that there's been some cracking down in this area. It is considered lender fraud. It's not loan fraud, but lender fraud, and we'll get into that issue in a little bit. But that is something that is cropping up in different areas.
What about a referral?
Well, it all depends. Now, when you say referral, I'm not exactly sure.
Refer the buyer out to another.
Well, yeah, that's another issue that you can refer them out. You're going to have to I would say you should be letting your seller know that. And the best way to do that, if you're going to be doing that, is to set up a custom and practice of saying, you know what, and this has been going on for long, I don't like doing dual agency. I just don't like it. I feel uncomfortable working both sides, and frankly, whenever I get cases that have a dual agency situation, that's the first thing the plaintiff's attorney tells me, oh, well, this is a dual agency. I always say, so what? It's not a big concern of mine, but they like to play it up, and I don't know what juries really grab onto that. But if your custom and practice always is that if you get a buyer coming to you directly, you just don't like it, whether it's you're going to get 6% or 3%, and I just use those terms, or those figures for easier reference, and you always refer them out, then referring them out when you have a situation where you'll still get 3% in either situation, I think you're fine. But if you're making an exception because, geez, I don't care, I'll still just get the 3%, you're going to have to let your seller know that this person came to me, but I want them represented by somebody else. Understand that you'll be paying 6% instead of 3%, or whatever the split may be. So, yeah, I already touched on this. You got to put your client's interests ahead of your own. As a fiduciary, you may owe certain duties under specific circumstances to investigate. There's a case, I believe it's the Salahuden case, but it doesn't make a difference to you, fine folks. that says, obviously, as a listing agent, in your disclosures, you don't have to do any investigation. However, under certain circumstances, as the buyer's agent, you need to either investigate or advise your clients to go out and investigate a certain situation, whether it's permits or you know, any other issues that you may have. As the buyer's agent, you can't simply accept information from others as being true. You can, as a listing agent, if your seller tells you it's best to put in any kind of disclosure that you put out there, seller states blah, blah, blah. Square footage is, and this is probably what you do every time, and I think on the MLS it probably prompts you to put in a filler. Square footage, 2,000 per, and then it's either county records, seller, or something like that. Always attribute. That's the best thing to always do, is attribute any information that you get. So, in a fiduciary situation, you can't simply accept information from others and pass that on to your client, unless, oh, there's unless. You inform your client, disclose to them that you haven't verified the information. When you're the buyer's agent, and somebody tells you the house is 2,000 square feet, and they say, oh, it's 2,000 square feet. Yeah, but I haven't verified. I'm just getting that information from the other side. You're more than welcome to verify that. And frankly, the CAR has some excellent disclosures on that. The buyer's inspection advisory, the seller, I know it's in the buyer's inspection advisory that you guys don't verify square footage. You can't verify square footage, and if it's important to you, go out and get a contractor, an appraiser, or somebody else. You know, written disclosures, buyers, plaintiffs, whatever, will always say, well, I get a stack of these like this, and you know, I'm just signing them, and you know, I didn't know. They just told me, don't worry, I know it's 2,000 square feet. That gets down to what he said, she said. So far, I've been pretty successful in and I shouldn't say things in court. I've been pretty successful in terms of those boilerplate, so to speak, disclosures ringing with the jury. They're certainly legal. They're certainly, you know, when you go in for surgery and you sign off on that informed consent thing, I guarantee you guys, just like me, never read a dang thing in that informed consent. But if, you know, things don't go well in the surgery, your family or you don't have anyone to sue. They're certainly legal, but they don't ring true with juries sometimes, especially, you know, if you have that the classic recently widowed elderly woman, or the young first-time couple buying a house. You want to identify the source of the information so that your client knows that it is just being passed along. I think I touched on that already, getting ahead of myself. Limit your scope or nature of your duties in writing. That's very well done by many of the forms, and I know Dave was just talking to me. He's got a nice little line, I don't know if he gives out or gives out in writing, if you don't mind. But the CAR forms do a pretty good job that you're not an accountant, you don't give tax advice, you're not a lawyer, you don't give legal advice. Go out there. If you need it, if you think you need that kind of advice, go get it. There's some good case law on it. I think I touch on it in a little bit. Unless right now? No. In a little bit, we'll touch on cases involving the failure to give tax advice. And by the way, that's just fine, courts say. Disclosing past or pending litigation. Give your clients, case number, the attorney's name, and advise them to go out and do their own investigation. Hey, I encourage you to go out there and give the attorney a call, ask to see his, at least the non-privileged documents in that case. Duty of good faith and honest and fair dealing. I'm sure you've heard that phrase throughout your practice. This is just the duties you owe to everybody in a transaction, including any lenders, including any title escrow, what have you. Upfront and forthright. Frankly, no single transaction is worth risking your reputation for. You always got to think when you're doing something, what you're doing is going to appear after the fact. That's when I sometimes get involved, and you're going to have to be explaining your actions at a later point. Provide all information that a purchaser would need to make a full and informed decision when they're purchasing. It may be the buyer, the seller's an agent as well. Seller's an agent with your office, anything like that. Just a full disclosure of anything that may, and as you know, may affect value or desirability of the property. That's probably another phrase you've heard throughout your practice. Deceitful acts. What's a deceitful act? One of the Supreme Court justices said he didn't know, what was it, obscenity. He couldn't define obscenity, but he knew it when he saw it. Difficult to define what is and what is not a deceitful act, but you know it when you see it, you know it when you smell it. Half-truths, kind of downplaying negative aspects of a transaction are going to be seen probably as fraudulent concealment, so you really need to make full disclosures. Black hat jury barometer. Now, I didn't write this. I'm not exactly sure what that is all about, but I think generally it's when you get into a trial situation, I think you got two strikes against you to some degree, and that is you're seen as the big bad realtor, and the poor humble homeowner is the plaintiff. And second of all, a defendant has been accused of something, and a lot of people kind of have the feeling that if you're accused of something, something must have gone wrong. That's just the way it is, you know. Innocent until proven guilty is a nice theory, but we all see the guy on TV in the orange jumpsuit, and, you know, we all jump to conclusions sometimes. So if they're accused of something, here's the biggie. Here's the biggie that you really can it's not worth getting involved in. Fraud kind of goes hand in hand with concealment. And there are specific definitions of what fraud, concealment are, and intentional misrepresentations as it relates to the law. And there are just specific ingredients. If things add up, you've committed fraud. And those are an intentional misrepresentation, which is a statement of fact, known to be false when you make the statement, made with the intent to induce the other side to believe it. The other side, in fact, does believe it, and it causes them damage. That's when you're in a fraudulent situation. It can be, like I said, active fraud, where you make a statement, and this roof has never leaked. Never leaked. You know, that's just that must just be a Coca-Cola stain from something popping. You know, somebody shaking a can and opening it. You know, that's obviously, you know it to be false. Made with the intent. Don't worry. Come on. Intent to induce them to purchase the property, and it ends up causing them damage, and that damage would be the diminution in value of the property with a leaky roof. So that is kind of your garden variety fraud committed against a buyer. There is also negligent misrepresentation.
Roger?
Yeah.
Can I just interrupt for a second?
Absolutely.
We have a couple of our agents that need to leave, and the fraud is the thing that we're kind of being hammered on right now with Connect.
Yeah.
So we've got a couple of agents that are fighting hard to keep their license, including our broker, because of the fraud issue. And you touched upon it earlier when you talked about you didn't call it a straw broker, but this is where we're kind of getting in front of this. Put down on your calendars August 30th, the Sacramento Association of Realtors, the Placer County Association of Realtors, El Dorado County Association of Realtors are all combining to have a seminar at the SAR building because there's so many companies and so many top agents that have been caught up into this. So they want to make sure that we don't get in. So I'm asking Roger to kind of spend a little more time on this. It doesn't really show it in the outline.
Yeah.
But,
it's
but
something
also
we just-
with fraud, and he's also our E&O representative, you're not covered with your E&O because it's, so I'm going to have you to take over from here if you would. And
Yeah, and I touched on it before, and I kind of gave you the scenario that we're seeing a little bit out here in the area. But in addition to it being a breach of your fiduciary duty and an intentional breach of your fiduciary duty, that will, as John just touched on, will not be covered by your insurance policy. You will not get the services of an attorney paid for by your insurance company. You won't get a judgment or a settlement paid for by your insurance company or by your broker. That I'm certain of. In addition, a lot of these situations are certainly going to be RESPA violations. If money is going somewhere that that is not reflected on the HUD-1, or that is falsely reflected early on in the estimated settlement statement, and then it's radically changed even though you knew back when the first estimated statement was done, you knew that wasn't going to be the split. That's certainly going to be a RESPA violation. So the Real Estate Settlement Practices Act. Yeah.
Roger, one of the questions that was asked is on referrals, and one of the things that John and I've seen that's going on up here with straw brokers is, and sometimes what they'll do is I'll refer it to a Keller agent,
Yeah.
and the typical referral is I get 25 or 30 and they get 60.
Sure.
And they're doing it the opposite. I get 70 or 75% and they get 25%.
Yeah.
They're just,
And if that other agent is doing nothing or next to nothing, that's, really, it's going to raise some big red flags with quite a few agencies that we'll touch on later. And I haven't even looked at what we're doing.
Define the straw broker,
Well, that's when you have the potential, the buyer, and you guys can kind of chime in too, because this is a new and emerging thing, and you may see it.
well, it's new and emerging, but it's a term that we used to use all the time
Oh,
back
really?
in the day.
Yeah.
But the Department of Real Estate are the ones that put this and attached it to two of our agents, and their write-up from the investigators to the attorney. The trial's pending. We're trying to get in front of it, make sure nobody's going to lose a license, but basically, it's as Roger touched earlier, except for instead of a different company, it was the same company. So you've got a listing agent, and the same 6.3% example, and they brought in somebody from their own company and said, hey, look, we're supposed to get, we're going to get 6%, but the guy I brought in is the quote-unquote straw broker who's supposedly representing a buyer who, in this case that they have, had never even met the buyer and shows on all the forms. So now this straw broker is getting, $500 or $1,000, for example, but the total commission, let's just say, is 10. So when you see the commission breakdown, $9,000 to the listing agent, $1,000 to the selling agent. Anybody that's out working with buyers right now, would you drive buyers all over town and make $1,000?
Yeah.
Hell no. So and the two investigators just happen to be ex-real estate agents. So they said, hey, wait a minute, we know what's going on here. You just brought your friend in here. You're defrauding the lender. It's RESPA. They coined the term straw brokers. And when I called, and the thing that's a little bit unique about this compared to other cases is they're pulling the brokers into it too. They said lack of supervision, you're supposed to know this. So when I called a few of the other well-known brokers in town that we've all known for a million years, they weren't too concerned about it until I said, hey, wait a minute, the broker could lose a license on this too. Now they're very concerned. And the quick, yeah, wait a minute. And it's a real quick acid test. That's it. You just take a look at your internal transactions. You've got a listing end, you've got a selling end, both in the same company, and the selling agent made significantly less than the listing agent. And there's a particular agent with a particular company that, by our best guess, has done this about 47 times in the last year and a half. Thank God it's not a Connect agent. But that's one of the reasons that Patrick Liu is our current SAR broker, and Dave Tanner, who used to be with Carlson Law Group, he's now the executive president of the Sacramento Association of Realtors. These guys are both in. I brought it up at an education committee meeting, and they said, "Hey, this is a hot topic. Let's get in front of this as quickly as we can. So you guys are going to hear about it today. The rest of the 3 boards are going to hear about it on August 30th. So we're working real hard to get in front of this.
Good.
And we found a few cases of it besides the ones that Department of Real Estate found for us. And we're trying to figure out the best way of getting in front of that and saying how to take care of it. Question?
Yeah.
So the issue with the dual agent is much of it is fraudulent acts where the listing agent is working with somebody so they get a higher commission than they would normally.
Exactly. So, like I said, if you know, the contract may say if it's a dual situation, you're only going to get 3%, but if it's not a dual situation, you get 6%. So you go out there and you find yourself a quote, you know, buyer's agent, so you can get the full pop and basically take money out of your seller's pocket. Yeah.
What if all parties are aware of everything? The sellers know that, hey, this person came out of the house, and you know, for instance, the listing agent is making more on some of these referral fees. But what if that's also because you know you have a cash buyers? Cash buyers come to listings all the time, wanting to work with the listing agent because they feel that that's what's going to get their offer accepted.
I have no problem with you being a dual agent. And of course, that's just in your
Well, I'm not
agency
talking
disclosure.
about-
You're not talking about just a cash buyer coming in and say, oh, I'll just work for you. I know I can get a better deal if we don't have another agent. Why don't you just do this and dual it yourself? You're
What
talking
if
about a
not-
different
what if-
situation.
I'm not talking about a dual agent. So, you know, to give you an example, a buyer comes in, they're an all cash offer. They're coming in at full listing price, but they're all cash.
Great.
We have other offers that, you know, are a little bit higher, but they're financing. Everybody thinks cash rules, you know, that's the roof. But then you say, hey, I'm not going to represent you, but I know you're a great offer. I'm going to let my agent represent you. You actually just handed another agent a transaction on a silver platter, which we all know it's very hard to get buyers into transactions. So in some cases, and I'm not saying that it's okay. I'm asking, and I'm putting a different perspective on it, so
No,
that you can tell us whether it's right or wrong. So that you say, hey, I'm making more money on this transaction because I just got you a great client that you didn't have, that got a house, how hard it is in the market that you don't have to go travel hours and hours for, and they're a great client. And I'm not dual representing, I'm giving that client to you, and my referral fee is larger because it's on a silver platter. The representation that you just handed to your agent, they're doing the AVIs, they're doing the TDS with them, they're going over all the disclosures. They are actually, you say, I don't want to dual represent you, not because I want a bigger commission, but because I actually need you to make sure that you have correct representation on your side, that the agent that you're representing or, you know, recommending to them to use is actually going to step up to the plate and say, hey, you know what, this house does have a leak. You know, so if those things come into play, but we're still getting larger commission, is that still considered?
I do know plenty of agents, and especially small offices a lot of times that don't have a good structure to them. They don't like dual agency situations, and if they do get a buyer coming directly to them, they will say, you know what, I'd rather have you be represented by somebody else. You got to have it disclosed to everybody, and you have to have it disclosed to the seller. Hey, he came directly to me, but I feel better representing you if he's represented by somebody else. You've got to understand, seller, that this is going to make the commission go, you know, under the agreement we have, it's going to cost you more money this way. Do you have a problem with that?
And on a short sale, I mean, I haven't been a part, I know somebody was saying 3%. I personally have not been a part of any short sale. On every listing agreement, it's 6%, period. And we offer 3% to, you know, to the buyer's side. If it happens to come from there, from the MLS, shown from the agent. But I don't see how that caps it down to 3%. And I never knew a lender to say, we're only giving you 3%. You know, you have to come. I mean, I don't know that commission ahead of time.
Yeah, no. I think you're right. Typically, in a situation, obviously, commissions are always negotiable, but we kind of, you know, just for our discussion's sake here, we can talk about 3% and 6%. And I agree. Typically, when you get your CAR form and you fill out your listing agreement with, you know, Joe Seller, it's usually just 6%, and then you put in there, I think on the listing agreement also you indicate that you'll be giving X amount, 2.5%, 3.5%, whatever it may be, 3% to a selling agent. And that's what you put on the MLS, you advertise it out there, you put there 3%, co-op or selling agent, and that's just fine. And in that situation, there's no difference to the seller whether or not it's dual or it's two agents, because 6% is coming out of that individual to Joe Seller's pocket no matter what. And I don't have there's no problem with that. It's when there is some manipulation of the relationships to increase the money going into the agent's pocket and decreasing the money going into the client's pocket. Which doesn't happen, it doesn't happen all the time. A lot of times, you'll see listing agreements where it's, 6% unless I represent both sides, and then it's 5%, something like that. I've seen those a lot, and that's fine, seller wants to.
Is that discriminatory of the lenders to say, hey, we'll pay 6% unless it's you?
No. This is the lender is now the owner of the property. He can come to any agreement he wants with his real estate agents.
And short sale, the lender's not the owner of the property.
Oh, I'm sorry. We were talking REOs is where.
No, we're talking
Short sales.
Oh, I'm sorry. Yeah, you're right. That's true. So I misspoke there. That would certainly be the seller is the seller, but the bank is going to be the one who's approving everything.
The bank's approving it, but they also have to approve the final HUD, and so they know who's getting what paid. Buyer's agent, listing agent, selling agent, because it's represented right there. Even if it's Connect Realty, they're approving it, so they know.
Yeah.
So as long as that's documented, I've never not had a HUD where it didn't indicate. If it's me, all me, then my name is next to each one of those Connect Realties. If it's me and another agent, it's my name and then that person's name.
Yeah, and I don't know when lenders are seeing the HUD one, if they're seeing
They
it.
see it through the entire process of the short sale, and they have to approve it before.
And I'd be concerned about an estimated being different than the final closing
But they have
statement.
to approve the final as well before we can even close escrow.
But what they don't always see is the internal commissions being paid. So if in that example, 6% was paid to, let's just say Keller Williams, for example. I like that example better. And they're going to host one of these seminars, which I'm happy about.
So are you saying it's
6% was paid, but
Okay.
then when you look at the internal, of that 6%, let's just say it was $12,000 on a $200,000 house. Of that 12 grand, 11 grand went to the listing agent, 1,000 went to the buyer's agent. That's where we're running into the problem.
as what the head said?
Right.
Is that what you're saying?
Because the HUD won't, they typically won't break down per agent. They'll just show
The HUD breaks
the
it down
company.
between selling agent and listing agent. You're
But
saying
by
that
company,
somebody's
not-
giving a large referral fee.
Yeah, by a company, not by individual typically. See, that's where the issue came in. They took one step further and they asked to see copies of emails. And like I said, my biggest issue with this whole thing is that they're calling it fraud, where it was like, I think the E&O should cover it because it was an error that somebody didn't know about. I didn't know that wasn't okay because it's kind of been the industry standard up here for the last 3 years.
Well, are there letters stating, I just personally, because I've done so many short sales and I've never seen this in any of my approval letters, where they will only pay, if it's dual agency or, same company or same person, they're only gonna pay 3%. Are banks doing that now? I just
They
haven't,
put out a statement that's like,
Now, there some REO companies, if you're dual agency or if you're representing both the buyer and the seller, they'll take it from 6% to 4%. So yes, they're out
But we're
there.
talking short.
No, we're
I
talking
think
about
he's
any
talking
transaction,
anything.
REOs or short sales. These,
Well,
these transactions that
Yeah.
Roger and John are talking about are happening inside of REOs and short sales. And
I've
one
seen
of the
REOs.
biggest issues is we keep getting questions about how I can justify giving you my buyer on a referral. And on that referral, you only take 30% and I take 70%. And Roger can correct me. Standard of practice out there on a real high referral, statewide even, is about 35%.
Yeah, 30%,
So
yeah.
if I get nailed on one of these things, and they're showing that I'm getting a 70% referral, and you're getting a 30% referral, you're now got the black hat, and Roger's going to have a tough time with you, right?
Hey,
I have a question about that from a fair trade commission standpoint. We're sitting in a room talking about setting commission rates. I don't
No.
think that's.
No,
Oh,
we're
no,
not.
We're talking referrals between agents.
well,
And saying they're set.
Well, I'm talking about what happened at the Department of Real Estate 3 weeks ago. The investigators brought up the number. So it wasn't a percentage, it was a dollar amount.
Yeah,
They said,
and
why did this agent get,
Industry standards, that it's run this way.
We're using hypothetical numbers, right?
Oh,
Right,
absolutely. Whether it's the 3%, the 6%, whether it's the referral fee, and absolutely, it's all negotiable, and it's not illegal per se, or it's not any violation per se to give the other agent, the buyer's agent, only $1,000, $500, $50. It's not, but it is going to raise a red flag, and they're going to look into it, and they're going to make sure that that's a legitimate. You're representing the buyer and you're representing the seller, because if you start seeing wind form documents that are counter offers that have been scratched out on the bottom, because we know it always puts that footer on there as to what computer it was generated from, and all of a sudden you look under there and it seems to all be the listing agent filling in everything, whether it's the offer, the counter offer 2, 3, and 4, and it's all on the same guy's letterhead. That's when you really know that that buyer's agent ain't really the buyer's agent. He's just a guy out there that we're going to use his name so we can get a bigger commission. So it's just red flags.
So short sale banks are really watching commission. I had a short sale, I had 6% on it. I was taking 3.5 because it was suggested I do that, so I was the listing agent, giving 2.5 to the buyer's agent. And the bank said no. The investor will not allow you to do that. It has to be 3 and 3. I had to get an addendum, had the buyer and the seller sign, and everything.
I
They're
couldn't
really
tell you
watching.
why. I couldn't tell you why they would
Yeah.
even be concerned with that.
I know, they're just watching it for some reason.
It depends on the time.
What,
Yeah.
what lender?
Wells Fargo.
we gotta remember, some of this stuff, hey guys, some of this stuff is going back to 2009, 2010. The Department of Real Estate is so backed up before I'm sure some of the cases that Roger's in court with right now don't have 2011, 2012 dates on them.
Oh, absolutely, yeah. My transactions that I deal with are a good year to 2 years in the past. I'm trying to think, I may have 1 or 2 cases that have a 2011 closing date, but everything is typically before that. Yeah,
Now, this is totally different than if you are an REO listing agent and you have some buyers in your office that you have as your buying agents, and their agreement in between you and them is they get 50-50. I have to pay you 50% of my commissions when I make a commission. And you and I are on a same operation.
Because we're handing them the leads, is what you're saying.
Yes, they're
Somebody's
handing us the
handing
leads.
buyer.
And I go in and I have, I don't know, I get a lead from a call-in. And I take that and I go to that call-in and they sign an agreement with me that I'm gonna sell be their agent.
I don't have a problem,
I have
and I'm the listing agent over
agreement with my
here.
broker that is the REO agent, that I pay her 50%.
Okay, I'm a little confused. You're the buyer's agent over there, and I'm the listing agent on this
Right,
REO.
in the same office. in the
Great,
same
okay.
office.
And I got this listing advertised on the MLS, and it tells everybody out there that I'm giving
3%.
3%. And then you're gonna come in with your buyer who you got over the phone, who just a call in. I don't have a problem with that so far.
Okay,
Yeah.
so when the deal is over and done with, everything's over and done, and we're splitting my commission, because I'm representing, my deal with them is 50-50 with the office.
Yeah, you're taking 50% of the selling agent's side based on your agreement with the broker.
Right,
Okay.
It's a
so that's
referral.
fine, okay.
Well, I wouldn't think that would be a
That's
referral. That just sounds like a general,
Now,
inter-office.
she's talking about a listing, I'm an REO listing agent. And I have an agent that works for me as my buyer's agent. So my agreement with that buyer's agent is all the phone calls that come in on my REO, she or he gets. And any sale that comes out of that, they get 50% and I get 50%.
Oh, okay. I don't have a problem.
Okay.
Yeah.
That shouldn't be an issue at all.
And that should be
because it's
handled as a
documented.
I
referral,
just
right?
wanted to make
Yeah.
sure that was different than what you guys.
But the difference is, because we are under a little bit of a microscope, what they would want to do is just see your documentation, and that wasn't just created for this one transaction.
No,
if that's an ongoing thing, you're completely fine,
Yeah.
because
Okay.
emails are now part of the transaction, which never
Sure.
used to be, so.
Sure, yeah.
Can I recap previous discussion just to make sure I got it? So, if I'm doing a short sale, and for some reason the bank said, if you're bringing both sides, it's gonna be 3%, if it's two, it's 3 each.
Got it.
Separate agents. And I do an open house, buyer comes in, I refer that to, another agent in my office, buyer agent, works with buyers. We don't like dual agency, quote unquote dual agency. It still is dual because it's under the city.
Agreed, yeah.
As long as I disclose everything to everybody, it's legal.
As long as you disclose everything to everybody, God bless you.
So you send a note to the bank and you say, here's how we're splitting this up. Buyers and sellers sign it. It's a done deal.
Yeah.
You know, I've got a question. You know, in regards to short sales, the short sale lender is not a party to that listing agreement. So how can they come in and alter that listing agreement?
Well, that's a good question.
Because it's all contingent upon their approval?
Because they have to approve the short pay.
Yeah, but how can they alter that listing agreement? They weren't a party to it.
Well,
Your listing agreement is between you and the
I've got
seller.
questions
But
about.
you're also asking the lender to take a $100,000 haircut. They have a voice in it. And then that's where we're in trouble, because then
They're gonna be
the
trading
RESPA gets
off
tacked on top of it.
the possible right to a deficiency in exchange for just doing the short pay.
Well, I know that there's some attorney groups out there suing banks for doing that exact thing, altering our listing agreement. Because that's between us and the seller. It has nothing to do with it.
Yeah, if it really should just be, you would think, in a bank just wanting a certain dollar amount. They just want this much. I want $300,000 on my $400,000 loan. I don't care what you guys do with the rest.
Right.
Now, we got big problems if money's going to the seller and things like that without their knowledge. Money can go to the seller with their knowledge, and in fact, some of the banks have programs that do that. I know B of A's got a good program.
And again, I'm sorry, I'm not disagreeing with you. That's why I see it. The only reason I have Roger ask him to come up here and talk about this is because the big issue that we have with a couple of our agents is that we may not have his representation because the Department of Real Estate's calling it fraud. I think that if you didn't know, and this is something that there's confusion on it from everybody and everybody's doing it, why isn't that considered an error or an omission? And then we have representation. When our guys, ladies, whatever, were sitting with the DRE investigators, I think they should have been sitting next to Roger explaining what the options are and walking us through it. But when you ultimately have, and again, I could be way out of line, and I don't want to hurt Roger's feelings here, but, you know, Crest Insurance would rather not pay a claim if they don't have to. So if the DRE says it's fraud, and it says right here in our policy that fraud was committed, they say, hey, we don't necessarily want to insure this big claim. That's my thinking. But I want to, if we have any more issues with it, which I hope that we don't, is that I want to make sure that Roger's sitting in there at the SAR hearings, at the DRE hearings, so that our agents are represented properly. And I don't want that to be at the agent's expense or the company's expense. I want it to be, we're all paying into E&O. We sure as hell ought to be using it, right? And we had some agents that didn't know that this was available, and before Roger leaves today, he's going to give you a number where you can call in and get some questions answered on a regular basis, and I'm much more impressed with Roger and his company's information than I am with the CAR legal hotline. So that's, I'm not disagreeing with you one bit. I'm just saying that the Department of Real Estate, for whatever reason, I think is taking a very narrow view of fraud, and they're hammering a couple of our agents and our past broker on it. I think it's wrong.
I don't think DRE can, I mean, if you committed fraud against your seller in the listing agreement, I would agree with that. But
And I don't mean to be a
short
smartass, but
sale-
it doesn't matter if you or I agree.
Yeah,
That's
but
what the
That's
Department,
gotta be legal.
well, that's what the Department of Real Estate's saying right now.
Two sides to
That's
every
contract
story.
law.
I know, I agree. You and I agree. But I'm just saying, I sat there when the investigator was just hammering. So I don't want to take on DRE as Connect Real Estate.
I think where the fraud comes in is really not any particular fact that you may see in there. Those just may raise red flags, and then they're going to look in and see if that truly was two agents working on a transaction, or was it a straw broker, a straw agent out there, just there on paper to pump up the commission. So if you're paying a certain, you know, the amount given to each agent is not per se some violation. It is if you're just trumping things up and making it look like there are two agents when one is just doing the work to pump up the commission. That's really the concern I have. Yeah. Yeah.
So you're saying anytime if we're accused of committing fraud, then our, insurance will cover us?
No, not necessarily. Not necessarily. Because you're going to get, I can't tell you the last time I saw a complaint come in where at least one of the causes of action was fraud. Every time there's a non-disclosure, they're going to claim two things. One, you knew about it and you didn't tell me about the leaky roof. And the other one is, you just didn't do a good enough visual inspection, and if you would have done your job negligent, you did it negligent. If you would have done your job, you would have seen this. So if a complaint comes in that has those two causes of action, one fraud, definitely not covered, and one negligence, almost always covered, you're going to be defended for the entire action. Your insurance company will hire me, somebody else at Carlson Law Group, somebody somewhere, and defend you for both the fraud cause of action and the fraud claim and the negligence claim. It is when there is an accusation made where there is no potential for insurance coverage, where the insurance company won't even hire you a lawyer. So if the only thing that all these facts add up to is fraud, that's when you're going to want to get your own lawyer to investigate, to perhaps look into the insurance coverage issue and make sure you're getting the insurance coverage you should. Yeah.
When does it go from representing the buyer and the buyer making the complaint on non-representation, switching over to the DRE saying that you are quote unquote defrauding the seller? So if the complaints are coming in from the buyer side, when's the last time a bank called you and said, hey, I want to go after this person because they've had fraud? Or when's the last time a bank has come after an agent for fraud? Or does it usually start off with the buyer saying, hey, there's an issue, then the DRE or the association looking into it and saying, you know what, that's not the issue anymore. So now the new issue is defrauding the bank, and that's what we're going to go after.
Yeah. There are things in the program of the various agencies that are now investigating, and they include lenders who are putting together, some internal task force to look into closed transactions in a lot of different ways to see if there has been any fraud in short sales, any dual escrows, anything, sales far below the broker price opinion, things, the BPO, things like that. And they will be scouring through, they are, and will continue to scour through closed files.
They go back, 3 years? What's the statute of
No,
limitations?
good question. They can bring accusations, and I don't know what the time on that is. I do believe it's 3 years. Did you? 7?
Yeah, the lady at the investigator said she thought it was 5. And
Well, there you go.
My understanding that we're only supposed to keep our files on 3 years.
And we only keep our files.
I wasn't going to argue.
When you get to statute of limitations in terms of lawsuits, as opposed to DRE complaints. By the way, that's where most of the DRE complaints come from. Is an unhappy client, buyer, seller, whatever it may be. That's the person who picks up the phone and gets the DRE complaint generated, typically, or his lawyer. And a lot of times they do that just for leverage. Although I don't see that too often.